could share your screen, maybe?
Oh, sure, I could do that.
We're live. Okay.
Take just a minute.
We just got to get settled here. This is House Corrections and Institutions Committee. It's Wednesday, May 13th. We are going to work on S-193. We have with us Legislative Counsel that worked on the first part of the bill that sets up the structure of who would be placed within a forensic facility. This language has been worked on by House Judiciary as well as House Human Services Committee. Health and Healthcare had any input on this particular piece, but they might have. So in order to understand what we're proposing in our amendment to S-193, we need to know what the rest of the bill says. I'm wondering where Mary went. She's working on some issue. We're waiting for Eric to be able to share his screen so he can put the document up on the screen.
Still looking at getting us a judiciary tomorrow?
I can. Yeah.
Okay.
For some reason, it's not loading very well.
Oh,
Oh, my wife is straight handsome right now.
Yeah, mine is,
there's something going on with the Wi-Fi?
Like that.
hey, do you by any chance have the documents on an email? Like if
Yeah.
you send me an email, I could try and load it that way. See if that might conceivably work a little better.
Onto the world of electronics.
Yeah, my Wi-Fi's out.
Hey, me too.
The Wi-Fi died? Really?
Recently though, because I had everything open.
It's it. I'm doing fine here.
I'm gonna restart my computer.
What?
Oh, I could try that, I guess. Turn it off.
Sometimes I have to restart for the Wi-Fi to kick in.
Right.
Not often.
My Wi-Fi on my cell is working.
Yeah, I'm on my phone. I'm on.
Right.
No, it's working on my iPad. Yeah, it's working on my iPad. I wonder if it's a location of where you guys are
Play in
sitting.
a second. Usually restarting it gets me back.
Yeah.
I'm back.
I'll log out to see if for some reason that
I'm back now.
did work for you. Did you send that email? Because I didn't get that either. So maybe that's just because I'm not in.
Excuse me.
All right. This seems to be working better. Right. All right, thanks, Tate. I will now, so now I'll sign in, and I think we should be good to go.
We had technical issues, that's what's happening. Wi-Fi,
So,
we had technical issues with
Oh.
Wi-Fi.
I heard Wi-Fi in my ears will right up.
There we go.
right.
Great. Well, now that we get started, Eric, welcome.
Thank you.
If you could introduce yourself for the record and get rid of those documents at the bottom.
Yeah. Seems before. Oh,
There you go.
I'm just better to be lucky than good.
Better believe it.
Good morning, everyone. Eric Fitzpatrick with the Office of Legislative Counsel, here to walk the committee through the latest draft of proposed amendment to S-193, an act relating to establishing a forensic facility.
What draft do you have? Is it 5.1?
I think it's 5 points.
Yep, that's the one we got.
All right, everyone's on.
What are you doing now?
We're all right. Excellent.
What do you need? Are you in listening or do you need? Oh, good. Great. Thank you.
Welcome, Madam Chair.
No worries. You
Welcome,
are.
Madam Chair.
We've got some empty seats. You want to sit up at the table?
You guys are so gracious with me. You know?
All right.
Oh,
You insist, I don't want to sit somebody sit the middle one.
the middle, yeah.
That's
Just me.
me. Kind of low, but that's all right. Welcome, Teresa. It's good to see you back in the committee.
Not in this room, though.
No, it wasn't
That's
in the
okay.
room, it's in the other room. Yeah,
Geez, now I feel really low.
Hey,
yeah, it's pretty
since we
low.
That's
don't
okay.
vote by division here.
Yeah.
It's giving me deja vu.
Okay, Eric, it's all yours.
Alrighty, thank you. And good morning again, Eric Fitzpatrick with Legislative Counsel, here to do a walkthrough of draft 5.1, I believe it is, yes, that everyone has of S-193. Just to, I know you guys had started on this yesterday. I wasn't sure, should I just sort of from the beginning, or was there
We
a
went through-
particular focus you wanted to have?
Yeah, we went through our section that we're offering our amendment to
Right.
the House Judiciary. We went through the legislative intent and we went through section 5 and section 7. We
Right?
didn't go through the guts of the bill,
Okay,
and that's what the committee wants to know, what's the guts of the bill.
Sure.
And how that relates to our amendment, which deals a little bit with the definition of the forensic facility and that feasibility plan.
and I didn't hear that last.
Feasibility.
Oh, right, yep, yes, exactly. Sounds good. Thank you for the direction. And so sounds like you looked at the legislative intent yesterday already. So that part you're familiar with. I think that first sentence about the general establishment of the forensic facility and its purpose under the Agency of Human Services is repeated throughout the bill in different spots. And the second sentence, I think, came out of this committee
You did.
about the corrections, or what role they would have, what the Department of Corrections would have at the facility. And you see it's not operating or staffing, I should say, with the exception of security services around the outside perimeter. And that also, you'll see, and you probably did already, a couple of other locations in the bill that similar concept and language is repeated. So that's the big picture legislative intent. That brings us to section 2. And the first issue that's presented in section 2 is what universe of people go to the forensic facility, right? Who is the population that would qualify? And you'll see there are these, I think we'll get them all on one page there, 1, 2, 3, 4. There's 4 different criteria that a person would have to meet in order to be sent to the facility. I think we had been talking about this in some ways, logically, it almost would make sense for number 4 to be number 1. I think we talked about that at some point, because you sort of think, and it doesn't have to be, it doesn't make a legal difference, but in terms of just which way you're thinking. But so having said that, look at number 4 first. The first thing is the person has to have been found not competent to stand trial. That's the first. And also backing up a half step, this section of the bill deals with that group of people who are found stand trial. It also applies to someone who's found not guilty by reason of insanity, but that's in a different section of the bill. So this is just one group of people the not competent folks. What criteria would someone have to meet if they were coming in through that route? And first one, obviously, found not competent to stand trial. That's number 4. All right, go back to number 1. Charged with an offense punishable by a life sentence. So it has to be a life sentence offense. There's about roughly a dozen of those in Vermont, criminal offenses that can be punished by a maximum term of life in prison. Number two, now you see a change here. The way it's currently written, the person has to be being held without bail, which, to be honest, if the person is charged with a life offense maximum, the majority of situations, they're being held without bail. So, in fact, that's one of the criteria for a life, to be held without bail. It's a life max. So, you're probably not having a significant effect, but it is an important one policy-wise to strike subdivision 2, because in that case, you're saying, all right, whatever the person is, what the previous draft had said, if the person isn't held without bail, in other words, they're under supervised release, for example, from DOC, there has to be this criteria that they have this qualifying condition, remember that from later in the bill, that upon the person's release would create a substantial risk of bodily injury. So we're excluding those folks from the forensic facility by that amendment. So you have to be held without bail. You can't be on this non-hold without bail
So it
status.
narrows even further who would be housed at the forensic facility from the Senate version.
Exactly right. Yep. And so now, so that's criteria number 2. Criteria number 3, they have to not be currently receiving treatment through an order of hospitalization. So in other words, they're not hospitalized currently and getting treatment through the Department of Mental Health. And also this proposed, and this actually has been in the last couple of drafts, it's just sort of struck to highlight that that is a decision point that is being reached by the committees, I think, that also the person under previous language had excluded people who were subject to an order of commitment. That's essentially the Act 248 universe of people, and not currently subject to an order of commitment through Dale. But although this, by striking the language, those folks are not excluded from the forensic facility up front, there is an off-ramp for them later on. I think that's the way the draft is currently. Been so many drafts of this bill that it's, hope I haven't missed a step. But I think that's where we're at. There's an off-ramp for those folks, but they're not excluded from the outset. Currently. All right.
Go ahead, yeah, Representative Wood.
Just so people in this committee know that, there's a 40-year history of successful service in the community for people under Act 248. And so I will tell you that I'm not sure that I'm totally comfortable with this at this point. I still have some uncomfortableness with this, because this is a what if situation. Somebody was under Act 248 and they committed one of those crimes while being under Act 248, then they could be housed here. And I'm like, okay, well, what problem are you really trying to solve, since that hasn't happened in 40 years? So this is why I still have a uncomfortable feeling about this.
So with taking that language out, taking line 12 through 14 out, you're still uncomfortable with taking that language out.
Right, because that says that they
can.
They can go in, but I come back to what is the problem that we're trying to solve? So if people have been successfully served in Act 248 for 40 years and have not committed one of those crimes up there,
Right.
why they've been under Act 248, why do we need to remove that as an exclusionary item? So
So you prefer to have it in?
I personally do, yes.
That's what I'm asking.
And again, the fact that it's struck here doesn't mean that we get from our office that this is an ongoing policy discussion
It's-
between everybody. And so we'll await
Still-
word.
Yes,
as you
no,
guys-
Eric has done so far what we have tentatively agreed to.
Right,
I'm just saying I still have an uncomfortableness with this.
right. Thank you. All right, so that's who goes to the forensic facility. Those are the 4 criteria. So what happens once you get there? Well, that's talked about in the next piece of the bill. So let's assume that the person meets those 4 criteria, they get placed at the forensic facility. What happens? Well, then the first issue that's being discussed here is how often do they get looked at again? They get reevaluated for competency. There's constitutional limitations. You can't just put someone at a facility and leave them there indefinitely. There has to be procedures in place so that they can be reevaluated and the court can determine whether they're still incompetent or not. So the timing that's set out right now is that the person basically gets reevaluated every 6 months. And if the Agency of Human Services medical director thinks that the person is likely competent to stand trial. So in other words, it's not an either or. Like they're on the 6 month clock, they get reevaluated. But in the meantime, at any time, the medical director says, well, the person's been getting competency restoration services. In my view, they actually probably are competent to stand trial. They don't have to wait till the next 6 month period. They can file for a reevaluation right then. So that's the proposal for how the calendar would work once the person is placed in the facility. So once in either one of those situations, either at the 6 month clock or if the medical director thinks it should be done, the court has to hold a hearing on this reevaluation. So that's what happened next. And at that happens next. And if the court at that hearing finds that the person is competent, so hey, remember they were not competent when they got sent there, but if the court says, aha, circumstances have changed, the person is competent now, then the court, and we got some language change here, they've gone back and forth about what should be the proper way to phrase that, what happens next. They've gone back to actually the original language on lines 14 and 15. I say original, that I think was as it was passed the Senate, that the court would basically just notify the state's attorney and the person's counsel so that then the criminal proceedings can go forward because the person is competent. But it doesn't say anything about where the person is placed in the meantime. It doesn't have to be changed anymore. So they can wait at the forensic facility until the trial goes forward, which would presumably happen reasonably quickly. So what happens if the court doesn't find that, though? The court finds out that the person is not competent, then the court orders continued competency restoration treatment. So if they're still not competent, then they stay in the facility, treatment continues. Again, subject to this every 6 months or any other time the medical director thinks they might be competent, those continued reevaluations would happen. So next point is restorability. So we've just talked about how that every 6 months review happens, but in addition to that, because there's also constitutional limitations on, as I mentioned, someone staying at the facility, generally the court has said, unless they're found to be dangerous, it can be for a reasonable period of time to find that they're restorable. So there has to be a restorable option avenue as well. And that's what this is. At any time, at any one of these hearings that we just discussed, any party can ask the medical director to include, that's line 3, an opinion on whether the person's competency can be restored, whether they're restorable. And if that happens, then that also is part of the hearing. So there has to be an evaluation that talks about that.
Eric, let me
Yeah.
interrupt 1 second, because
Yeah.
I think we got to go back to this question from a minute.
Yeah,
And Eric, I don't know if you can answer this. Maybe the chair
No,
can help us with this. Why is it only every 6 months and not every 3 months? If we're trying to work with these people and get them going, why are we waiting? Why is it only happening twice a year and not 4 times a year?
it's a pure policy decision. So it's just sort of looking at some examples of what other states have done, trying to come up with a time that seemed reasonable. But a reasonable determination is a policy decision for you guys. So if people felt like it should be more or less frequent, we can certainly.
Okay, thanks. I just was wondering where that came from.
so did the 6 months come from the Senate, or was that put in by House Judiciary? Do you remember?
I'm not sure about that. So I'd have to go back.
Can check.
Okay, thanks. I was just curious, just seems like a long time actually, but
Right.
maybe, but I don't.
People with who are under the jurisdiction of my committee are not likely to actually ever have restored, they're not going to restore their competency.
Right.
This is mostly for people with mental health challenges.
Is this more like a check-in then? Teresa?
No, I would say, it will take some time, between therapy, medications, whatever else, will be provided during that time. I'm not an expert on competency restoration. But I think, certainly, the individual could ask for it to be sooner if they feel like they're going to be not guilty, but, and that provision is there, so.
Okay.
And it was in the version that passed the Senate.
Yeah, it was.
Okay.
Yeah.
All right, thanks.
Yeah.
That helps a lot.
Yeah, it
Appreciate
was.
that.
Yeah, absolutely. So,
Connor,
I just wondered, like, yeah, I'm a novice with the whole process, Eric, so
yeah,
you have the, I guess it would be, the court would find that the competency has been restored, but there would be a lag period, which it looks like here where there's the continued treatment and everything. Could your competency be taken away in the period between when it's restored and the actual trial then?
in other words, the court might find that you've been restored, but then in the meantime.
You deteriorate?
Yep, absolutely could find that. And there is, in fact, even if you're, see just the kind of forks in the road, these decision points that come up when the court's looking at this restorability issue. Let's say they find that the person has been restored. And if they're restored and not dangerous, then they get released to the community. But there's a process for if the person then like their competency deteriorates as you described, and it looks like they're dangerous again, then they can be brought back to the facility. And that's
Okay, thanks very much.
Yep. So that's, sorry, go ahead.
no, go ahead.
Right,
Interrupted.
well, interrupt any time with questions, because this is a detailed and can be complicated process. But on that fork in the road point, so someone has asked for this restorability evaluation, the court can either find it looks like the person's restorable, or it looks like the person's not restorable. If the court finds that subdivision 2 their competency can be restored, well, then they order continued treatment, because the court's basically saying, well, the person with treatment could still be restored. But if the court finds not restorable, well, then they have to have another hearing within 60 days. And that's the dangerousness here, because it's at that point that the court's going to be saying, well, they may not be restorable, but if they're dangerous, then they stay for treatment, continued treatment. If they're not dangerous, then they get released into the community under supervisory conditions. So that's the general process that is outlined here. So you see there's a forensic risk assessment that has to take place before this dangerousness hearing. I believe this language got added to make clear that the treatments are evidence-based has been added. You'll see that in a number of instances throughout the bill, but this is all part of the risk assessment, the items that have to be in the risk assessment. You'll see added on lines 4 and 5 is an opinion as to whether the person is a person in need of custody care and rehabilitation. That's that Act 248 universe. And so the examiner has to offer an opinion on that, because you'll see that also becomes an important decision point for the court. Because remember, I mentioned that off-ramp for the Dale universe, that is dependent on that particular recommendation. So this is so under 4A, that's basically dangerous. The court's holding this hearing, this 60-day hearing, to determine whether these are people that are not restorable. If the person is dangerous, then the person orders continued commitment, consistent, line 15, consistent with the risk assessment. So in other words, depending on how dangerous the person is, it might be inside the facility, it might not be. Depends on what the risk assessment says.
But the standard is clear and convincing.
Yes, yep, exactly.
That's the middle of the road.
Right. More than preponderance, less than beyond a reasonable doubt.
The state has to prove this.
Burden is on the state.
It's on the state.
Yeah. If the court does order this continued commitment, so in other words, the court said not restorable but dangerous, they do that, then you again have a periodic review. In this case, it's every 12 months, or again, upon the medical director's certification that they're not dangerous anymore. So that could happen anytime, but they're, again, the idea being to have these off-ramps in place so that it's not indefinite. Now, if the person is not dangerous, I just mentioned that state's attorney doesn't demonstrate by clear and convincing evidence that the person is dangerous, then the court orders the person released. And that's to see Romanettes 1 and 2. There's care and treatment plans that have to be placed in the order. And then the person has to comply with those. They are under the supervision. You see, this is lines 19 and 20. This is something that the committee has been interested in. Who's supervising the person? You'll see the various departments listed there.
So let me just back step a little bit. So in 5, the state's attorney does not demonstrate by clear and convincing evidence that the person is dangerous to the public.
Right?
Could the person could still be incompetent to stand trial, correct?
Yes, we're assuming at this point that that is the case. The person remains incompetent.
And then if the state's attorney cannot prove beyond clear and convincing evidence that the person is dangerous, then the court can order the person to be released back into the community.
That's right. Assuming they're not restorable. Is that kind of the track we were in? Yes, that's
I
right.
want that to be clear for the committee, because it's a different world that we normally don't work in.
Eric, so, is the clear and convincing evidence that the person, either does or doesn't pose a danger, is there any consideration given to whether or not that demonstration is supported by services? So, for instance, some might argue that a person would be dangerous, except for the fact that they're receiving these services and they're receiving supervision under, I'll use Act 248 because that's what I'm most familiar with. But this argument seems to be just a straight out, are they going to be dangerous or not dangerous? And so if they're going to be dangerous, they can just be kept there. But the reality is that there should be a determination made about whether or not they would be dangerous absent the supervision that is being talked about in lines 11 through 15. But I don't see that there.
Excuse me. Yeah, I would think that the determination of whether that evidentiary threshold has been met, that clear and convincing, anything that's relevant, is going to be open for the court to consider. And if it was relevant, that the person might not be dangerous as a result of receiving services or treatment of a certain type, that would be relevant for the court to look at.
Yeah, it doesn't say that there, though. It doesn't say that the court shall consider a program of services that could be provided in the community.
Yes, not specific, not expressly, right? Just leaves the standard as it is.
Okay, need a pen. Have a pen. Your drawer pen. Thank you.
You need some paper, Teresa?
Yeah, well, yeah, I don't want to just take
No, that's
something up and leave it. Thank you.
So these are for folks. So these are for folks that have been deemed not restorable.
Right.
They may have been held for a year or 2 years. But there is in the human services mental health world that people shouldn't be held beyond a certain length of time. Is that correct? And they should be in the least restrictive environment. That's sort of my 30,000 foot level understanding. It's not our world, when I used to dealing with this, but this is in the human services world. Is that-
Yeah, I
is that
mean,
correct?
that's why there is a continued review. So there's a continued review process so that if you're under an order, whether it's going to be in the community or not in the community, you have the right to have a continued review to determine if you should still be held. So I think that is, or if you should still have to receive services in the community. So the community order is just as binding as the, order of being held in the facility. Part of what the issue has been is that there has been insufficient supervision by the Department of Mental Health of people in the community under orders of non-hospitalization. So, I was just talking to the chair of judiciary and, Department of Mental Health says that they can't do that. And I said like, well, they could do that. They just don't want to do that. And there's a big difference. And the community services under Act 248 are being provided by the very same designated agencies that the Department of Mental Health works with. And so the expertise exists within those agencies. Probably not all of them, but the expertise does exist. And so it is a change of practice for the Department of Mental Health. But that's different than saying we can't do it.
It just, yeah, they're doing it right now for folks under Act 248.
Yes.
And then they're saying, well, we can't do it for folks who are not under Act 248, but under Department of Mental Health custody.
They haven't had that level of what I would call residential supervision. Where people know where you're living. You may have staff that are living with you. You may be, there might be alarms on the doors to know when you're leaving, those kinds of things that are employed now for people on Act 248 in some circumstances. And so I just, I know that, different folks within AHS were testifying, and I think that it's just important for us to distinguish between
Can't and won't.
somebody who doesn't want to versus
They
they
don't want
can't.
Yeah, they don't want to. Sure.
I just really want to punctuate this, so thank you. It is critical that that we somehow make this point with this bill. Because this gets at the heart of supervision on folks who have been released. And right now, the only answer that is being presented to us as at all remotely possible is that DOC is going to do that supervision. I don't believe that. So I don't know how to put that in here to make clear that can't versus won't component of this with some shall language. But yeah, I just really want to punctuate that.
And paragraph I is as close as we've gotten to that. So previously, that really would have only been Dale.
Yeah.
Listed up there. But housing and supervision.
Yes.
Those are the key things that were not there previously or have not been historically there for mental health.
And these folks that would be released, that may not be competent to stand trial, but they're not a danger to the public. This is the category we're talking about.
Yep.
Would be under the custody of the Commissioner of Mental Health or Dale
Or health.
or Health. Anyway,
They're going to come back and say health isn't going to be good there, but I'm just.
right. But I just want to put that out on the table. They are right now, they would be, for those folks in this language, they would be under the custody of the Commissioner of Mental Health or the Commissioner of Dale or the Commissioner of Health.
I'm not sure if it says custody or not, to be honest. Is that?
That's what I'm wondering. I mean, they're under the supervision, but would they be under the custody of DOC?
I don't think they're under anybody, well, unless they're under Act 248. Is that saying custody, Aaron?
No, I think it's supervision.
It's supervision.
Yeah.
Yeah.
So that's what I'm kind of getting at. Is it implied then that those folks are not under the custody of DOC through the bill?
Says it later.
Yeah, I think it makes clear later on that these people aren't in DOC custody.
That's just what.
It's just
So
clarifying.
it implies that these folks, they're under the custody of the state in some level. Right?
Right.
So they would be under Dale
Not custody, it's supervision.
supervision.
It's different. Some of these folks might be under Act 248, in which case that is a custodial relationship. But I know next door that they're still looking at DOC supervision
In the community,
in the community.
which is kind of tough, and that's a real in-depth conversation, because there's certain requirements that DOC does that maybe these folks won't even be able to comply with those certain administrative requirements, and then they get violated or could get violated.
Well, which is why I think you do need the clinical departments, the departments who are
Right.
offering those kinds of services and have that expertise to be involved. I don't think it'd be,
One or the other.
I think in some cases I don't know if there's provisions for joint, but if there's a role for both.
Yeah, sure. And I don't object to it being in there. I'm just wondering who would qualify for supervision by the Department of Health? What type of person?
People with substance use disorder.
Substance
Yeah,
use?
that's what you're
Okay,
talking about. Yeah.
gotcha.
And they testified in our committee that once the substance use, so through treatment, once the substance use disorder has been treated, and, somebody with substance use disorder, like, lots of different things, it's an ebb and flow, it's an in and out. So, but they said that most of the time, people in the situation would then fall back on a primary mental health diagnosis. So I think that they don't see their role as being particularly active here. But
That's just in those those small situations.
who are just have substance use disorder, right?
What about dementia?
Pardon me,
What about dementia?
that would be under Dale.
Okay.
And so you'll see line 5, person shall be released from the supervision of the appropriate commissioner unless they continue to be shown to be a danger every 12 months. So I think in some ways, the whether or not you call it custody or supervision, the real point also is that at any time, the person can be brought back to the forensic facility by the I think it's the person, how to rephrase that? The commissioner that has the supervision of the person. So
They don't go back to the facility. I'm looking at page 7, lines 3 through 8. They shall be released from supervision if the state's attorney demonstrates clear and convincing evidence that they're not dangerous. But if they can't demonstrate that, then the person can be continued on treatment and supervision. And it would imply community supervision, right? Not going back to the facility. I'm on page 7.
okay, all right, so page ahead of you there.
Page 7B, lines 3 through 9. So if the state's attorney cannot demonstrate by clear and convincing evidence that the person's not dangerous, so the person's still dangerous. They can treatment can continue and supervision is necessary. So that implies they would still be out in the community. They would not be sent back to a forensic facility, correct?
Correct. Exactly.
So here you have, Eric, in lines, 8 and 9, you have the notion of the state's attorney saying, okay, well, absent this community supervision, they would be presenting a substantial
They become
risk.
dangerous.
They become
essentially.
dangerous,
Yep,
right?
exactly.
And that same notion needs to be further up in the process when the judge is considering whether or not to release them from the facility.
That continued treatment would,
That absent
absent
the treatment that is,
Right.
pointed out here, that they would be dangerous.
dangerous.
So the absent treatment part doesn't come into play the way it's written right now at that initial determination. And it should, because we're not proposing that they be just released. We're proposing that they be released with supervision. And so that needs to weigh into the decision. That was my previous point.
Right. So Eric, are you making a note of that to putting some language to that effect at the first part of the first court hearings?
I'm making a note of that so that you guys can continue that discussion.
Like that.
That's the judiciary section of it, so I don't really know how we're doing that between the committees, but I'm making note of it, so I know exactly the point.
You and Katie have like a very difficult job
Yeah.
right now, trying to navigate this between.
Yeah, it's a
Three
tricky one.
committees for sure.
Yeah,
Okay, thank you for doing that, Eric.
yeah, absolutely.
Lisa, for bringing that up.
Yeah. So this next subsection has to do with the notice that victims get so that they can appear at the hearing if they choose to. Court inquires if the victim is present and gives them an opportunity to speak. So we're now getting to, this is the Act 248 population. So remember, the court could find if the person's not restorable that they are dangerous and therefore they keep getting services possibly at the facility. They could find that they're not dangerous and not restorable, then they get released. Third option, the court could find that the person can't be restored and that the person is a person in need of custody, care, and rehabilitation. That's the Act 248 definition that I know this committee has seen. That is as the result, I think, of an intellectual disability, if I remember correctly. And if that's the case, then this is the off ramp that I mentioned earlier. So in that situation, if and the definition you may recall of the person in need of custody, care, and rehabilitation includes language that the Dale commissioner has to be able to basically to provide placement in a designated facility. So that is also incorporated and folded into this piece. But so this is an option that the court could order if it meets that definition. This language that you see, say from lines roughly 4 to 12 or 13, is tracked actually is more or less the same as the language that's in Act 248. So it's the same process of what the person has, the rights that they would have if they are in Dale custody pursuant to this. It's just in sort of as a different avenue as to how they get there.
I think,
Oh, go ahead.
so, you know, we're fine with this language, obviously, because it's language that we're already familiar with and act under. I just think it's an interesting dilemma on a civil rights issue that it's only people with intellectual or developmental disabilities that are placed into the custody of a commissioner when in community placement. And any of these other people who are considered dangerous aren't placed into the custody, and it's only supervision. And I think I'm not a
I agree with you.
civil liberties expert, but
That's why I was bringing that up earlier.
it seems to be a disparity that is not warranted. I'm just bringing it up because I think, you know, you got supervision and custody are not the same thing.
I know. No. So are you saying under Act 248 for folks with intellectual and developmental disabilities? That's what Act 248 pertains to. It doesn't pertain to the whole gamut. It's a real
Correct. It's a
small-
narrow group of
it's very
people.
narrow. That they are, even when they're in the community, they're under the custody of the commissioner.
Yes, they are. Yes.
And for all the other folks who may not be competent, their competency may not be restored, but they're not a danger to the community. They're out in the community, but they're not under the custody.
Supervision, it says.
Right, and
supervision.
that's what I asked earlier.
Yeah.
The same thing, they're not under the custody of Department of Mental Health or Dale or Department of Health. They're only being supervised by those departments.
And I think that's been, I'm sorry.
Oh, no, go ahead.
So
I think that's been honestly part of the problem. You know, folks with mental health issues have orders of non-hospitalization.
Mhm.
Enforcement of those orders has been not consistent, I think people would say.
Because they're not under the custody of the Department of Mental Health, because it's an order of non-hospitalization. If they had an order of non-hospitalization, they'd be under the custody of the commissioner.
I don't know if that's the same thing. I'm not an expert.
I'm not either.
I have no idea.
Yeah, what's the finality if the court finds a person's competency cannot be restored? Are they still entitled to the 6-month evaluations there? Or is that a whole different process?
It becomes a year. If they're not restorable, then the timeline gets a little longer. Yes, they do get the continued reevaluations, but they're not.
But it's a year then?
Yes, and if the medical director can always certify earlier, but
Okay.
yes.
So if a person, just want to play out this scenario. So a person has been deemed by the court that competency cannot be restored. And has also been determined that they would be dangerous to the public. They would be held in the forensic facility. Correct?
There is some leeway for, they would be held in a manner consistent with the report they get back about, I'm drawing a blank on the name of the report, what it's called, the risk assessment, sorry,
Risk
risk assessment. So yes, so yeah, that could be the facility, but it might not necessarily be. It's intentionally provides some discretion there that if the dangerousness can be treated in a way that isn't necessarily at the facility, it provides that option. But yes, likely at the facility.
So if they were to stay in the facility under that situation, would they be reviewed every 6 months or 12 months?
Let's see. If they stay there, I think that in that situation, they go 12 months. Yeah.
So they would stay in that facility. Now, what's going through my mind is in the human services world, mental health world, and I may be off base on this, but what I have heard is that there really is a limit to how long we can hold someone where they need to be moved to a least restrictive environment. Is it like 3 years? Something like that. That's why there's these off ramps. So I'm just trying to figure out how long would we essentially hold someone in a forensic facility? Would it be for the rest of their life? Or
The judicial review once every year.
once every year, so it'd be up to the courts to make that decision and state's attorney.
For this small population, yes. Because they've been charged with charged with a crime that calls for a life sentence.
Well, they're not competent to know that.
What this whole
That's the
thing's
issue.
about is the fact that they're incompetent or insane, but they've been charged for lifetime, so. Yes, that's why it's a 12-month review.
So in this universe of people that have been transferred to the custody of Dale, right? Then what happens next is that the commissioner of this referring to Dale has to provide appropriate custody care and rehabilitation in a designated program. So that's the commissioner's responsibility. Now, this one does have a 1-year maximum in the sense that the court may order continued treatment at the forensic facility for a period not to exceed 1 year if the court finds that the commissioner is not currently able to provide appropriate care in a designated program. So in other words, we're giving the Dale some time to make sure that there's a designated program available. As long as but they have a 1-year max on that. And then at that point, program needs to be made available.
Now, again, these are just for folks under Act 248.
Yeah, exactly.
Intellectual and developmentally delayed. It does not pertain to all the other folks that might be held at the forensic facility.
That's right. And so that order that I just mentioned that allows the person to stay at the forensic facility because there's not a designated program available, that one has to be reviewed by the court every 90 days. So they're basically the Dale commissioner has to keep the court apprised as to whether or not there's a designated program available. And the court has to make findings at the review that similar findings that it made in the first place about whether the person is still appropriate for the program. Now, this subdivision D there provides the commissioner at any time they can certify to the court that, hey, the program is now available. So the court commissioner can come in and do that anytime. Some general language that the committee has looked at a number of times. No real changes here other than clarifying that it's the medical director, not the clinical service director for AHS, who's responsible for providing competency restoration services. continues at the program as we've described, unless the person is released through one of these other methods that's just been talked about. So this is something I mentioned earlier, talking about who is doing the monitoring while the person has been released. You see, as appropriate for the needs of the person, the Commissioner of Mental Health, or Dale shall monitor compliance with those orders of release. So again, it's going to depend on the condition that the person has, which commissioner is the one doing the monitoring. One of them is, this is the language I was looking for earlier, line 13. If while the person is out in the community being monitored, the commissioner monitoring the person, so whoever that is that's doing the monitoring, notifies the court if it looks like the person needs to be returned to the facility because now they become dangerous again. Remember, that was the question that came up earlier. But what if the person is out in the community, but now it looks like they weren't dangerous before, but now they are again? The commissioner, whichever one it is that's doing the monitoring, brings the person back in immediately and lets the court know. Then the court has to have another hearing. State's attorney does have that clear and convincing burden again, saying it has to establish that the person is now dangerous, or they get released.
Eric, I'm just wondering, on line 17 there, we got rid of that notion of a qualifying condition. Does that change what should be said there?
What do you mean got rid of the qualifying
Well,
condition?
in 2B in the very first page. Other qualifying condition.
Very first page of the bill, you mean?
Yeah.
You're
The
talking
section about,
two? Are you talking?
Section two, I'm sorry, yeah.
Oh, that was just, that was a particular universe of people that wasn't going to be included on the basis of the fact that they
Okay.
were not being held without bail. The qualifying
Okay.
condition still applies
Still
throughout.
applies to everything.
Yeah.
Okay,
The
okay.
qualifying condition is life and bail, right?
Now, the qualifying condition refers to the mental health
The
status
incompetence.
that resulted in them being found incompetent, basically.
Yeah, this might be spelled out somewhere else, Eric, but do we ever go into what monitoring actually means for these purposes? Like,
Nope. That's up to the discretion of the commissioner.
okay. I do feel like there'd be a very broad range of what that entails, but
Right.
And may I ask, who decides whether it's Commission of Mental Health or Aging Independent Living who decides which of those organizations shall actively monitor
Yeah, I think since this is all being run by the Agency of Human Services,
by default?
by default, exactly, they can designate the appropriate commissioner to be the one who, based on the health condition that the person has.
Not the courts, but the agent.
Correct.
AHS.
Correct. Yeah. So that's how the person can get brought back in if they were previously not dangerous, but then the commissioner monitoring them thinks that they become dangerous. This is the involuntary medication section, subsection 8. There's no changes here. The committee's looked at this. This is a Supreme Court standard for when involuntary medication can be provided to a person for purposes of restoring competency specifically, which is what's going on with people who are at the facility under this track. Language here providing that the defense has the right to conduct their own independent evaluation whenever an evaluation is required, so they can have their own results introduced at the hearing. It's a separate section here. This is a related but different issue, more of a criminal procedure issue, allowing criminal charges against a person in a misdemeanor case to be dismissed when someone who's been found incompetent is involved in this case, what's been gone on for a long period of time without any action. So provides a notice for victims to come and testify as well. If it turns out there's going to be a dismissal, if the court decides it's a case that's appropriate for dismissal, it has to provide the victims an opportunity to speak about whether or not that would be appropriate. Subdivision 2A and B. Moving on to section 4. Now this is really not going to be many changes here. This is we just talked about the folks who are at the facility, placed at the facility because they're not competent to stand trial. This is a separate group of people. This is the folks who've been found not guilty by reason of insanity. A different situation because there's not an ongoing criminal proceeding against these folks. Charges are no longer pending because the person's been found not guilty by reason of insanity. So that's why you see lines 14 and 15. It's necessary to have this language that the committing court retains jurisdiction over the person for these proceedings, because otherwise, since there is no criminal charge anymore, criminal court wouldn't have any jurisdiction of the person. So similar qualifying point though, line 8 and 9, it has to be a life maximum offense. And they're found not guilty only by reason of insanity. If that's the case, they get placed at the facility. And it's very parallel proceedings to what we just looked at, very similar type of situation. They're placed there, they're provided with treatment as long as they're dangerous. Again, if they're not dangerous, they can be released. Similar process to what you just looked at. But as long as they are dangerous, they remain there, continuing to get treatment. They have these periodic reviews. And it's a very similar parallel process to the one that you just looked at for folks who are not competent to stand trial. In this case, you see there has to have a hearing. You see line 16 and 17 within 60 days following admission. Because in contrast to the competency folks, the folks who came in on the incompetency track had their competency evaluated right away. That was the last thing that happened in the criminal division. So they had a recent hearing already with these folks that didn't have that same thing. Evidence-based treatment, again, I mentioned that's added in several different places in the bill. Again, though, at these periodic reviews, there has to be a risk assessment because the whole issue here in the NGRI context is dangerousness. That's the issue for these folks, because you can't have your competency restored in this situation. They've never been found incompetent to stand trial. For them, it was only not guilty by reason of insanity. So the issue is not restoring competency for this group of people. It's only, are they dangerous or not? And so that's the burden on the state's attorney at all times. They have to establish, you see line 16 as an example, by clear and convincing evidence that the person has a qualifying condition that upon the person's release would create a risk of bodily injury to another person, which is essentially saying dangerous. So again, as I say, these are all just parallel procedures, very, very similar to what you just looked at for the competency universe of people. Similar timeline, state's attorney has to petition the court for review every 6 months. In this case, they are a bit longer as the time periods go on. So it's every 6 months after the initial commitment, then it's every 3 years after that, and every 5th year after that. Again, also upon certification by the medical services director. In this case, though, you have another avenue for the person. You see line 10, the person themselves can petition the court for release on their own. So they can say, hey, I want the court to review my case because I don't think I'm dangerous anymore. So that's another opportunity for court review.
Could you have a real Fisher Price question, Eric? So to be hospitalized involuntarily, you generally have to be considered a danger to yourself or others, right?
Right.
If a person in a situation of not guilty by reason of insanity is being kept there because of their chance to be a danger to others,
Yep.
why are they not involuntarily hospitalized in like another hospital instead of the forensic facility? I guess I'm having trouble with that little distinction there, you know? Does that make sense?
Yes, I think the way the current law is, which this does not displace, is that if you are dangerous to yourself or others as a result of a mental illness, that's the current statute for someone being placed in a hospital or hospitalized. That still remains. But if it's there for some other reason other than a mental illness, that's the sort of intent of the bill to sort of fill that gap. One of the gaps that it's intended.
Okay.
So it's the mental illness folks still exists. So they would be hospitalized if they were a danger to self or others because of a mental illness specifically. But if it's for some other reason, then
Like maybe a TBI would
Yep.
never qualify for involuntarily being hospitalized in Vermont, right?
At least not through that DMH.
Yeah, okay.
Definitely not through the.
I got it. Thanks.
Yeah.
We do ask later on in the report that they're supposed to come back with our committee thinks it would be appropriate to expand Act 48 to people with brain injury and people with dementia,
Okay.
or Alzheimer's. So
That's happening now.
No, that's in the
it's
plan.
in it's in the plan that we asked them to come back with.
They say they can't do it. Which yesterday they indicated they couldn't do feasibility plan.
Yeah, they also said our committee, it was a minority of our committee who was opposed to DOC operating or whatever the question was, which is not accurate. That was 100% of our committee.
Yeah,
But once again, someone would have to apply to the court in reference to an individual that's a danger to themselves or others. Unless they break the law, an individual who's incompetent cannot be held without someone petitioning the court and saying that this is necessary because he's a danger to himself or someone else.
You actually have to commit or have been charged with a crime.
Okay, so in
Under
the
this-
absence of a crime,
In the absence of a
I
crime,
have someone held in a hospital. That has to be a petition to the court, yes?
involuntarily.
yes, involuntarily, yes. Yeah,
It's an involuntary commitment.
Yes. Yep.
It's not a voluntary commitment, that's up to.
Right.
Right.
But our state hospital is for involuntary commitments.
and that only applies to people with mental illness.
And my tangent is, this committee's heard of my personal example. A young man was just given, the parents bought a tent, bought him a sleeping bag, bought him a way to cook, and they put him into the local park because they can't keep him at home anymore. He's attempted suicide multiple times. Hasn't broken any laws that has convicted, but he is now literally living outside in a tent because the state isn't in a position to do something for him unless, I guess, they petition the court to say, my son needs to be institutionalized.
And that's something that's come up recently in another case that I'm familiar with around the availability of public guardianship. And it only applies to people with developmental disabilities or people over the age of 60 and over. So if you're not above that age and you don't have somebody who, so those folks can be his guardian if the court determines that. But if they are not able or don't want to do that, there's no provisions for public guardianship that essentially kind of controls what people do.
Very large gap is my point.
But that could be the parents of that person could go for guardianship.
Yes, they can.
They could go
Yeah,
for
they'd have
guardianship.
to petition, yeah,
Yeah.
they'd have to get a court order to say we're going to,
That's true for any guardianship.
yeah.
All right, so this is, again, the person can be released or is released if they're found not dangerous, similar in the NGRI context, that's the incompetency one that we just talked about. Similar language you see here, line 15, when the person is released, the appropriate commissioner monitors them and lets the court know if they become dangerous, they go back to the facility. And then victim notice provisions parallel as well. So that really takes us through the NGRI process, which, as I said, is very similar to the competency one that you looked at first. So that brings us to the definitions. Forensic facility defined here means it's taking out the word residential. It's a locked, secure facility for placement used as a therapeutic community residence, where you see it's the Agency of Human Services, line 4, provides for secure competency restoration of persons with a qualifying condition who are involved in the legal system do not require hospitalization level of care. And clarifying that it's just that, and if you're transferred pursuant to those two sections we just looked at, in other words, competency and GRI. Added a definition of competency can be restored, which is out of the federal definition. The federal process has a definition language that's similar to this. Substantial probability that in the foreseeable future, a person will attain capacity to permit the proceedings to go forward. Here's the qualifying condition that the chair referenced earlier. What is the qualifying condition? Any condition, whether mental, congenital, or traumatic, however acquired or developed, or any other circumstance that resulted in a person being determined incompetent to stand trial or not guilty by reason of insanity. Some procedural points about how the evaluations are conducted. You'll see that the commissioner of BGS can do contracts with evaluation providers. Person has to submit to the evaluations under subdivision 3. Again, some operational language here. It's the Secretary of Human Services, line 5, that establishes and operates the locked secure forensic facility for competency restoration, evaluation, stabilization, treatment, and care, persons who have been transferred there. And then it specifies forensic facilities, clinical, forensic, forensic, and competency restoration services. So those services are overseen by the AHS medical director. So that's got nothing to do with corrections, you see. And then you clarify in the next sentence, DOC shall not play a role in the forensic facility's operation, provision of services, internal security, or post-release monitoring of any residents. Again, there's that sort of exception, you remember from the first intent language about security around the perimeter, and you'll see that somewhere else as well. And some language about how the forensics facility is going to be run, supporting which types of programming in the therapeutic community residents, safe evaluation, treatment, stabilization, and care of the folks who are there. Again, see subdivision 4, line 6, follow the direction of the Agency of Human Services medical director, who shall oversee all forensic, clinical, and competency restoration services. So again, it's trying to clarify that who has what responsibility there, which person. I think that was clarified somewhere else for DOC as well, but that may be in the plan. So again, these are the types of services that are provided at the facility and what responsibilities are with which department. Talking about public records, no changes here, generally speaking confidential with some extensions. Legal representation, see subsection D, people who are admitted and maintained there have a right to be counsel appointed from Vermont Legal Aid. And this kind of goes to the question earlier about who is, like you specifically, you were asking, well, who's the person supervising while they're out on release? This kind of this overarching subsection E there, Secretary of Human Services regularly consults with all these commissioners when performing the duties. So they're going to work out the particular roles of each person when it comes to specific duties, like, for example, who's doing the community monitoring for people in a given population. Some reporting requirements, rulemaking. And then I think these came out of this committee. You may have already went over this with Katie yesterday. You probably did. Yeah. Striking a couple of sections, the rulemaking, for example, because you're awaiting the feasibility plan. I think you probably went over that as well. The
So we
feasibility
got
plan.
rid of one of the report back because we did include in the feasibility plan, go before joint justice, so to speak.
Right. Which reminds me, and Katie may have already covered this, but I think we were trying to make sure we had the right meeting dates for the justice oversight reports.
I think it does work. It's August and November, which is good because August is kind of at the beginning of some of our meetings. November is towards the next to the last meeting that we would have in off session.
Did Katie talk about that already? Because we heard from Hillary, she thought that that maybe the committee was going to be meeting in June, July, and September, but not August. And so
We haven't made those determinations yet.
right,
Depends when we start our first meeting. So
right,
we could have, it depends when we adjourn from here.
Yeah.
And then say we have our first meeting at the end of June,
right,
we could have the next meeting in the first part of August.
right.
We just don't know. I mean, you've staffed it in the past.
Right.
Back, way in the previous iteration. It just depends when we get started.
Right.
Sometimes we may not have the first meeting until July, depending when we get out of here. So the thinking is we could have it up front. And then prior to our last meeting, which is usually in December.
Right. Right.
August is, it's the best guess.
Yeah. And it's probably fine. If for some reason you end up not meeting until
So by,
September,
yeah,
you could say at or before. I think Hillary sent me some language that had been used for some other report. Justice Oversight was getting back that said something like have it before. But I think it's really
I
not.
think August works because I'm
Right.
not remembering the dates that work. I've got to look back on that. The dates that work for staff right now is towards the end of June,
June, right,
beginning of July.
right, right. Yeah. Either way, I think if you end up having
I've
it.
got to work, I'm gonna look at those dates.
Right.
Nothing's been confirmed.
Right. All right, I think no other changes that I'm seeing.
This is helpful. Any further questions of Eric? So you folks have a better feel of where the bill is and what changes were made between House Judiciary as well as House Healthcare and Human Services. I'm under the impression that Representative Wood is going to be also working on some, a little bit more language in some places. It's my hunch, and that would be more directed towards judiciary, working with that. Is my hunch. Any questions of Eric before he can go back to judiciary?
Back down the hallway.
Yeah.
Really helpful.
Thanks, Sarah.
Yeah, absolutely. Any other questions that come up, which I'm sure there will, but other questions, let me know and Sarah will be back in on this before too long.
Martin is still planning on voting this out tomorrow.
I saw that on the agenda. I haven't specifically talked about that with him, so I don't know. I did see that on the agenda, but as we know, there's a lot still going on, so.
Yeah, lots still.
Right.
Thank you, Eric.
Thank you. Yeah, we'll see y'all soon.
Yep, so let's go off of YouTube. Let's take a break. Let's come back at 10:30 and we will then have committee discussion on how we proceed with our amendment.